He's the California man accused of murdering 4 college girls with his speeding BMW on the infamous PCH along the coast. Prosecutors say this wasn't an accident. This was more than that. Fraser Bohm is charged with 4 counts of murder for what allegedly happened to the Pepperdine students on an October night in 2023.
Murder requires proof of a very particularized mental state. They argued it. There was a counter argument that we couldn't make because they didn't provide the data and the information to us.
Bohm could spend years in prison if he's found guilty, but one of the biggest names in criminal defense is in his corner, and this week, his attorney made some shocking claims in court in hopes of changing the course of this case. We're on the case, presented by Law&Crime. I'm Stewart. The defendant in the story we're talking about today, Fraser Bohm, is facing the same amount of murder charges as Bryan Kohberger did in Idaho. That is something that Fraser Bohm's attorney, Alan Jackson, brought up at a previous court hearing, as he has been arguing that this should not be a case involving murder charges.
Your Honor, this case, I've said it before and I will reiterate, is deeply, deeply tragic, and that cannot be overstated. But tragedy can't substitute for probable cause for murder charges.
So there's Alan Jackson arguing a motion to have the murder charges dropped in a courtroom this week in Malibu. Now, we'll get more into what Jackson had to say in a moment and what the judge decided. Now, you will remember, if Alan Jackson looks familiar, that is the attorney who represented Karen Reed. He is one of the biggest names in criminal defense. And before we get into what he had to say in court this week, I want to go back to October of 2023. That is when this tragedy happened, and that is where we need to start when talking about this case. So back then, Fraser Bohm was 20 years old, and he was behind the wheel of a BMW that was gifted to him by his parents for his 16th birthday. And Fraser was allegedly driving 104 miles per hour in a 45 mile per hour zone. Fraser reportedly was speeding on the Pacific Coast Highway. And if you've ever been out there on the West Coast, it is incredibly scenic, but it's a dangerous stretch of road. It goes right along the Pacific Ocean. And most of the pictures that we found with the PCH, they're from after the wildfires in January of 2025. But as you look at these, you get the idea of the kind of road where all of this took place. And it was October 17th, 2023. Fraser Bohm was allegedly going more than twice the speed limit. And these 4 girls were getting out of a car on the shoulder of the PCH. 20-year-old Niamh Rolston, 21-year-old Peyton Stewart, 21-year-old Asia Weir, and 21-year-old Deslyn Williams. The 4 girls were sorority sisters at Pepperdine. They were seniors. They were just months away from graduating college and continuing on with their lives, really just starting their lives. But police say Bohm hit them with his car, and all 4 girls died. And the area of highway where Bohm hit them is known as Dead Man's Curve. According to KABC, that is a stretch of the PCH where most auto accidents happen. Bohm was arrested a week later. Hey guys, real quick, running a business is hard enough. Oftentimes you're having to do things manually or rely on a bunch of apps that don't even talk to each other. That is where our partner and sponsor Odoo comes in. Odoo is an all-in-one business management platform with a full suite of integrated apps that seamlessly connect all your operations from sales and accounting to manufacturing and even shipping. Odoo can automatically generate professional, sleek-looking sales orders, invoices, and vendor bills, and it can automatically assign sales teams, send email updates through each sales stage, and even use AI to pull reports that help you with your decision-making. For manufacturing, their apps can sync inventory with real-time production and purchase updates so you never run out of stock. And when it comes time for accounting, that is also fully automated. Odoo can create invoices, track expenses, and even summarize data with AI to save you hundreds of hours. The best part, you can choose your app and even build custom workflows so it's all fully tailored to your business needs. Take your business to the next level by consulting with an Odoo expert today for free at odoo.com/OTC. Now, Fraser Bohm was not just charged with 4 counts of vehicular manslaughter, he is facing 4 counts of murder. Prosecutors say that Fraser accelerated from 93 miles per hour to 104 miles per hour in just 2.5 seconds before he hit the girls. That's according to data from the BMW's so-called black box. And prosecutors argue the acceleration is proof that he was driving in a way where this crash should not be considered an accident. It should be considered an act of murder. In court this week, Bohm's defense, though, has argued that there was key evidence not presented during a preliminary hearing where a judge found that there was enough probable cause for the murder charges to continue on. And now Alan Jackson is arguing that those 4 counts of murder should be dropped. He's not arguing that the vehicular manslaughter with gross negligence charges that his client is facing should be dropped. Just murder. This is what he said.
The motion asks the court to dismiss counts 1 through 4 and 1 through 4 only, the murder counts, because the preliminary hearing on those counts and those counts alone, according to this motion, were fundamentally compromised. The prosecution withheld the very evidence that would have allowed the defense to show at the preliminary hearing that speeding on that particular stretch of PCH, while it may be dangerous, certainly even reckless, was not historically or objectively an act whose natural and probable consequence involved a high degree of the probability of death. It's not a motion about whether or not the collision was devastating. Everybody in this courtroom knows that it was. It's not a motion about whether speeding is inherently dangerous. It is. We can all agree on that. But implied malice murder requires more than just tragedy and more than just danger, Your Honor. To repeat that incredibly important standard, it requires proof that the natural and probable consequences of that act and that act alone, as one court put it, is nearly certain to cause death. That's the line between gross vehicular manslaughter and murder. And that's the evidence that the prosecution failed to provide to the defense. And that's the evidence that goes directly to that line. The procedural vehicle that we have before us, as the court said in the Stanton motion, common law motion to dismiss, it matters, and it involves constitutional issues. The motion is brought as both a common law statutory motion to dismiss and, as it's, to the extent that it's applicable, a renewed 995 motion. California law recognizes this very remedy. It recognizes it for a reason, because where the denial of material evidence prevents the defense from exercising a substantial right on behalf of Mr. Bohm, this is the remedy. This is the court. The preliminary hearing, as the court well knows, is not simply a formality. It exists to weed out unsupported and grave charges before the defendant's forced to stand trial on those charges. The defense has the right to confront witnesses, to cross-examine witnesses, to do that meaningfully, to present evidence in its own defense, to impeach prosecution evidence, and to negate elements of the charges. And when favorable evidence is withheld from the preliminary hearing, the harm is not cured by saying, well, it's okay, they've got it now, they can use it before trial. The harm is that the magistrate's probable cause determination, Judge Edberg, 3 floors down, his probable cause determination was made on an incomplete record, and Mr. Bohm's statutory and his constitutional rights for the preliminary hearing, at the preliminary hearing, they were denied when they mattered most.
Now, as we look at some of the facts of this case that have been presented in court to this point, why Fraser Bohm was going so fast is very key in where this trial could go. Prosecutors say a man named Victor Calandra noticed Fraser Bohm driving too fast prior to the crash. He allegedly told Bohm to slow down at a red light before Fraser sped away and crashed a short time later. The Pepperdine Graphic newspaper says that Victor Calandra says when he and Bohm ended up at this red light, he looks over and he sees Fraser Bohm in the car, and he claims that Fraser had his cell phone between his legs, under the steering wheel. He was possibly texting. And then he allegedly told Fraser, quote, "Hey, you need to be careful. You are going to hurt yourself." And he says the light then turned green and Fraser Bohm gunned it. And it was only seconds later that he hit those 4 girls and they died. But Alan Jackson is countering that narrative that's been presented by prosecutors. He claims Calandra lied about what he saw that night, and he claims there's cell phone data that proves it.
At the preliminary hearing, the people relied very heavily, almost entirely, on Mr. Calandra to portray Mr. Bohm in a very particularized way as being irresponsible and distracted immediately before the collision. Mr. Calandra testified that Mr. Bohm was texting on his phone and that phone was between his legs, under the steering wheel, and his thumbs were moving on the keyboard. The phone data later produced and analyzed by a forensic expert contradicted that testimony completely. That phone was locked from 8:15 and 59 seconds p.m. until 8:30 and 6 seconds p.m. There was no user interaction with that device during the entire 15 minutes prior to the accident. The expert established unquestionably that Mr. Calandra's testimony was false. When he suggested that he personally saw Mr. Bohm with both thumbs he personally saw Mr. Bohm with both of his thumbs sort of ripping away at the keyboard, texting away, that was in fact a lie. He could not have seen that because there was no texting, there was no interaction. And it makes one wonder why Mr. Calandra thought it was prudent to lie under oath or to lie to the authorities about that. We'll save that argument for another day.
So this week, after Alan Jackson made those accusations, here's how the prosecution countered.
So the court understands procedurally the phone was in the possession of people. The sheriff's office was making attempts to crack into the phone because we did not have the password. So we had a physical phone, but what we're really talking about here is the encrypted data that was on it. The people were able to get a partial download of that phone, not a complete download, because we didn't have the password. We informed the defense that it was not a complete download. We provided what we were able to get off of it to the defense prior to the preliminary hearing. They had that data. It showed that there were no texts, there were no calls, there were no interactions with apps during the time period immediately before the collision. So that was known to the defense, and that was used as part of their attempt at impeachment of Victor Calandra. Because Victor Calandra, before and then at preliminary hearing, said that the defendant was texting. That was his testimony that came out. And I inquired, how do you know? You don't know that he's...
Maybe you should go outside.
questioning whether or not he actually could, from the position that he was in, tell that the defendant was actually texting on his phone. And he was cross-examined on that by the defense. And the use of the phone data that the defense says that we never should have engaged in was when the defense requested a stipulation to the fact that there were no texts or calls that went through at that time, which, based on the evidence that we had, the people were more than willing to do because it was the state of the evidence, and is still the state of the evidence. What they're saying is that they were able to, by getting the phone and having the unlock code, which occurred after the preliminary hearing, and we had a hearing here in court about it, and that's when the court ordered it to be done, that somehow that extra information now turns Victor Calandra into a liar that undermines the entirety of the people's case.
Bohm also allegedly told investigators after the crash that hitting the four girls was an accident. He says that he had to swerve because he was trying to avoid hitting a car that was next to him that had already hit his driver's side mirror. Prosecutors argue they found the other car. They say it didn't have any damage. Prosecutors also say that Fraser Bohm knew that speeding could have tragic and deadly consequences because they say Fraser Bohm spoke to deputies after the crash and he talked to them about an experience where his friends had died in a car crash. Prosecutors say he brought this up on his own because he was asked if he was familiar with the phrase speed kills. Here's what Jackson said about that.
They relied on his friend's accident to argue that because his friends died in a car accident because of speeding, Mr. Bohm would know that speeding results in fatalities. Except at the moment the people made that argument, they were also in possession of a police report that indicated that the primary cause of his friend's tragic death was DUI. It wasn't speeding. The primary cause was because his friend was driving at a .12 blood alcohol content. They had that report in their possession and was never provided to the defense during the preliminary hearing or before the preliminary hearing.
Now, this week, Jackson also argued that speeding's a chronic issue on that stretch of the Pacific Coast Highway, and he says there is key data that the prosecution should have turned over for that preliminary hearing.
Here are some of the facts related to the exculpatory information that we've laid out in myriad exhibits before the court. After the preliminary hearing was over, after it was settled, after the holding order, the defense obtained what the prosecution did not produce: collision data, Caltrans reports, sheriff's reports, Lost Hills Station reports, CHP Malibu Task Force reports, City of Malibu materials, Captain C2, as the court now knows, was the captain at Lost Hills Station, her deposition testimony, her presentation materials to the city, Senate Bill 1297 materials, the Stantec safety study, an expert analysis. That's just a smattering of the things that we recovered, all obtained by us, and all within the prosecution's custody and control before the preliminary hearing. And the picture those data paint is materially different than the picture that was presented at the preliminary hearing. The evidence that we presented, that we have now uncovered, shows that there is chronic speeding on PCH. It shows that there are recurring collisions, one after another after another. It shows governmental recognition of those speeding issues and those recurrent collisions, and government recognition of a serious traffic safety problem in Malibu and on that particular stretch. But importantly, and most notably, that data also shows that fatal collisions are rare. Not just rare, Judge, extremely rare, relative to the volume of speeding, the volume of citations, the volume of collisions. On that precise 0.8 mile stretch, and this is where I'll start supporting my argument with the PowerPoint to give the court some visuals. On that precise 0.8 mile stretch between Carbon Canyon Road and Las Flores Canyon, in the 10 years before this case, SWITRS, which as the court knows is called the Statewide Integrated Traffic Records System, SWITRS, identified 129 reported collisions. The actual case listing establishes this, and the government's own report establishes this, and it's run from the government's own database. Not a database that we created, a database they created and they had. Then Caltrans produced approximately 50 additional collision reports that were not included in the SWITRS data. So we have 129 from SWITRS and an additional 50 from Caltrans. And that was also obtained by subpoena by the defense after the preliminary hearing, and it was never produced in the discovery. Together, that's approximately 179 collisions on the same stretch of road over the course of 10 years. The only fatal collision in that combined data set is this case. The only fatal collision is this case. And that speaks directly to the objective element, Judge. The prosecution's entire theory at the preliminary hearing depended on treating excessive speed on this stretch of road as conduct whose natural and probable consequences involved a high degree of probability of death. That was their theory. They can't run from it. They can't hide from it. They said it, they theorized it, and that's what they presented to Judge Edgar. But the undisclosed government history, the 10 years worth of government data, shows exactly the opposite. Repeated speeding, repeated collisions, and not a single other fatal collision in 10 years on that stretch of road. Not one. And we didn't have that data to make that point in front of Judge Edberg at the preliminary hearing.
Prosecutors responded by arguing evidence wasn't withheld.
The framework of what we're talking about and foundationally what is required, it appears that the defense initially argued that there were 2 violations, and now they've brought up a third of the people not providing evidence, which is favorable to them. It appears it's the citations, the statistical information, the sheriff's reports relating to collisions on PCH, none of which involve the defendant. That's that first body. The second being the phone that belonged to the defendant that was in the police custody. And then the third, and I'll just address this quickly because I think it is can be easily dealt with, is the report from the Ventura County Sheriff's Office that lists the DUI as being the primary factor for Mr. Ocean's collision and death, and it also indicates speed. Now that third one specifically goes to the defendant's subjective knowledge. He knew, because he was asked the question, are you familiar with the phrase, speed kills? And he brought up this information. His understanding of the dangerous to human life that speeding represents is what's important for the subjective. The fact that there were other factors involved, and he even says, I don't know the full story. That's in the interview that he gives with the deputies. But his understanding is what is important in that case, which was that speed was a factor in the deaths of his friends, and indeed it was. So I don't see how the other information can go into to change his knowledge post facto. The other thing that we have to look at is what the court is basing the understanding that these are, as the defense is alleging, that these are favorable to the defense. And so much of that is born on the foundation that speed alone, number one, is the people's theory, and number two is the standard by which the courts look at for implied malice. Neither one of those things are true. It hasn't been true when the case occurred, when it was filed, wasn't true at the time of the preliminary hearing, it's not true now, and it won't be at trial.
This is what the judge said about whether those murder charges should stand.
In my view, the non-disclosed evidence does not foreclose the possibility of a high degree of probability of death and may even support a finding that the defendant's acts are acts, the natural and probable consequences of which are dangerous to human life, in that they involve a high degree of probability that they would result in death. Mr. Bohm was not denied a substantial right at the preliminary hearing because the people had no constitutional obligation to disclose the evidence at issue. This alone mandates or requires a denial of this motion, and the court need not even reach the question of whether the evidence at issue would affect the magistrate's or would have affected the magistrate's determination of probable cause, such as the defendant's entitled to dismissal. But even assuming, arguendo, that the evidence at issue was required to be disclosed to the defendant pursuant to Brady or any other discovery statute, the addition of the non-disclosed evidence to the evidence heard by the magistrate would not have affected the probable cause determination in this case. The motion is respectfully denied.
So Fraser Bohm will continue to be charged with murder and 4 counts of vehicular manslaughter with gross negligence. He is slated to go on trial September 5th. That will do it for On the Case, presented by Law&Crime. Subscribe to us on YouTube and Spotify, and we're also streaming on Peacock. I'm Chris Stewart. We'll see you next time.